Arbitration is a private, non-national system of dispute resolution by an impartial tribunal. So you take yourself out of the court system into a separate system for resolution of disputes that is not tied to any particular national system of justice. We'll come on to certain ways in which there are links, but it's outside of the judicial process of any country. It's based on the parties' agreement. If you don't have an agreement to arbitrate, then you default back to local court jurisdiction. The award is final and binding, so it is an enforceable decision. As a general rule, there is no appeal on fact or law. There are limited exceptions to that under the laws of certain seats that often can be excluded by agreement.
Make sure that you are familiar with and competent using the online technology. That can't be stressed enough, given that this is key to the virtual mediation. As we've discussed, ensure that there are regular breaks, both for the mediator and for the participants. That's why we have the separate breakout rooms. Attempt to have technical support if possible. This can be provided by the ADR organization that is administrating the mediation. It could also be provided by one of the law firms. It's simply helpful to have somebody who's very proficient in the IT technology and can help if something does go wrong.
The expert's role is to assist the tribunal with understanding evidence on complex issues, and so there is an expectation that they will be independent of the parties to the arbitration, even though their fees are likely being paid by one of the parties. Common areas for expert evidence are quantum of damages, technical or scientific fields, and foreign law. The extent to which experts in these fields are likely to be full-time experts as opposed to one-time experts varies. The rules applicable to expert evidence come from a number of sources which are rarely set out in detail in either the Lex Arbitrae or rules specified in the arbitration clause. Rather, detailed rules applicable to expert evidence are more likely to arise through adoption by the tribunal of a rule set such as the IBA rules, or by tribunals issuing directions applicable to the expert evidence.